Joining us now, former
Good seeing
Assistant
you.
U.S.
Thank you.
Attorney, Fox News contributor Andrew McCarthy. So you've been critical of this case from the start. Now Trump's team is looking at potentially demanding a mistrial. You know, from where you sit, Andrew, you're an expert here. When you looked closely at it, should this case scare everyone, and why do you think that?
Well, Liz, this is more about your side of the street than mine, but I think that if you set up a government climate for business where they can put you out of business under circumstances where, even though they're alleging fraud, there are no victims of fraud. And we have a situation where they not only can put you out of business, but under this idea of disgorgement, take back $250 million in profits. Again, in a case where there's no victims and where the banks and insurance companies that did business with the Trump organization were sophisticated financial actors who knew exactly what they were getting into and made money on the transactions. If that's the kind of behavior that puts you out of business in New York, who the hell wants to do business in New York?
So they can take away an entire business empire, no due process, no jury, no need to show harm or damages, no need to prove intent to defraud, or anyone was defrauded. The state doesn't have to establish any creditor or bank relied on any of the misrepresentations, the allegations there, or misled. They don't need to show any victims. I mean, the Manhattan DA's office looked at this same case and declined to move forward with it.
Yeah, Liz, that's right. This case started out way back when, actually, in my old office, the federal prosecutors in the Southern District of New York, who had the Michael Cohen case, they were the ones who initially looked at this and decided not to go forward with a criminal case. Then the Manhattan District Attorney's Office moved heaven and earth to try to make a criminal case on this, to the point of going up to the Supreme Court not once but twice to get Trump's financial records. And when they finally obtained them, it turned out that it wasn't the mother lode that they were expecting. But Tish James, who is the state attorney general who brought this case, Liz, she has access to, in the civil context, this monstrous statute that you just described, where they can accuse you of a persistent pattern of fraud, notwithstanding that there are no fraud victims, and they don't have to prove intent to deceive.
That's really something. I mean, we get it. We've been following and reading as much as we can about the case. I mean, prosecutors are asking things. Why the value of Trump's Aberdeen property, for example, increased by, I think the report said, $245 million within 2013, 2014, when it appears little was done to the property. But it's how the case is being carried out that you're pointing out, Andrew. I mean, the judge already pronounced Trump guilty. The court's now in the penalty phase. Again, no jury. They're going to ask for a mistrial. Trump is saying, I should have a jury on this.
Yeah, well, they brought it under a provision that ordinarily doesn't have a jury trial. I actually think they should have fought harder to try to get a jury. I think they might have gotten one if they had done that. That's not clear. It's just my view of it. It's not really just the penalty phase. What the judge did here is there's 7 claims, civil claims. He decided one of them, but it's the most important one prior to trial, and the other 6 are still being tried. That's supposedly what the trial is about. But really, you're quite right that what he's done is he made the essential fraud finding against Trump even before the trial started. And this exercise is just about how much he's going to let Tish James run up the score. You know, how much of the $250 million does she get to disgorge? I think Trump recognizes that if he's going to get any relief here, it's going to be in the appeals process, not with this judge.
Andy McCarthy, thank you for joining us.